Welcome, everyone, and thank you for joining us for today's Paid Family Leave webinar for employers and HR professionals. I'm Sarah McDonald from the Branding Stakeholder Engagement Unit and here at the board, and joining me is Courtney Valle from our Office of General Counsel, and she will be on hand to answer your questions. Today, we'll provide an overview of New York State's landmark Paid Family Leave benefit, including contribution benefit rates and updates for 2025, and resources to help you share information with your employees. We will be using the chat feature to receive your questions today. You may enter your questions throughout the presentation in the chat box located on the right side of your screen, but we will wait until the end of the presentation to answer them. Courtney will answer as many of your questions as she can, but if you have questions that we don't get to today or think of something after the session ends, we'll be providing you with resources at the end of the presentation. Your name and email were given to us when you signed in today. However, if you have a specific topic you'd like to discuss more in depth with the board, please share that topic along with contact information in the chat box so the appropriate board staff can follow up with you. The chat settings are configured so that only panelists can see any questions or comments that come in, so you do not have to worry about others seeing your personal information. Before we get started today, we ask you to please keep in mind that the board is unable to provide legal advice, which includes guidance about what you should do in specific situations. If you have specific questions or concern about a request for paid family leave, you should contact your disability and paid family leave insurance carrier, as they are the entity that makes the decision to pay or deny benefits. So let's get started. In today's presentation, we'll provide a brief refresher on New York's paid family leave and how it works, update you on the 2025 benefit contribution information, review who is eligible for paid family leave, review key responsibilities as an employer or HR professional, go over some similarities and differences between Paid Family Leave and Family and Medical Leave Act, or FMLA, and highlight the many resources that are available to you. Let's start with a little background. In April 2016, New York's Paid Family Leave, the nation's strongest and most comprehensive paid family leave policy at the time, was signed into law. Paid family leave is employee-funded insurance that helps employees be there for their family when they are most needed. Because of paid family leave, workers across New York no longer between caring for their loved ones and their jobs, as we now have employee-paid insurance to help in these critical times. New York State's paid family leave provides you with a structure to help your employees care for their families in time of need. Paid family leave has been shown to increase workplace morale and employee retention. Fully funded by employee payroll contributions, New York State paid family leave provides job-protected paid time off to employees who need time away from work to bond with a newly born, adopted, or foster child, care for a family member with a serious health condition, or assist loved ones when a family member is deployed abroad on active military service. In addition to paid time off, New York Paid Family Leave also has strong employee protections. Employees are guaranteed to return to the same or comparable job after taking paid family leave. A comparable job is defined as a position with comparable employment benefits, pay, and other terms and conditions of employment. Employees are guaranteed continuation of health insurance on the same terms as if they had continued to work while out on paid family leave. If employees contribute to the cost of their health insurance, they must continue paying their portion of the premium while on leave. Employees are also guaranteed protection from discrimination and retaliation. Requesting or taking paid family leave cannot be held against them. As an employer or HR professional, it may be helpful for you to know the kinds of questions employees are asking and which could help direct the guidance you provide and the materials you make available. These are the top questions to the PFL helpline for employees. We'll cover the answer to all of these questions throughout today's presentation. First, though, let's walk through a quick review of the 3 basic uses of paid family leave. We'll start with bonding with a child. Paid family leave provides both parents time to bond with a new child within the first 12 months of birth, adoption, or foster placement of the child. Parents who work for different employers can take paid family leave at the same time to bond with the same child. Parents who work for the same employer can take it at the same time unless their employer prohibits it. In that case, they can take leave separately over the first 12 months following the child's birth, adoption, or foster placement. It is important to note that the expectant parents cannot take paid family leave for their own pregnancy. They can take it after the baby is born because paid family leave is used to care for someone else. A parent may be able to take paid family leave before the actual adoption or placement of a child if an absence from work is required for the adoption or placement to be finalized. Paid family leave is also available for employees to care for a spouse, domestic partner, child or stepchild, sibling, parent or step-parent, parent-in-law, grandparent, or grandchild who has a serious health condition. A few other important notes for family care. Domestic partner is defined broadly under the paid family leave law and includes people who are not related by blood in a manner that would bar marriage in New York State and are dependent on one another for support. For example, an employee may be able to prove that they are in a domestic partnership by showing that they own property together or have children in common. A legal relationship is not necessary. It doesn't matter if these family members live outside of New York State or even outside of the country. Employees can take paid family leave to care for their family member as long as they're within close and continuing proximity. In other words, present at the same location as the family member they are caring for during the majority of the paid family leave period. This may include necessary physical care, emotional support, visitation, assistance in treatment, transportation, arranging for a change in care, assistance with essential daily living matters, and personal attendant services. In order to take this type of leave, the employee's family member must have a serious health condition. A serious health condition is defined as an illness, injury, or condition that requires either inpatient care in a hospital, hospice, or a residential health facility, or continuing treatment or supervision by a healthcare provider. The third type of leave is for assisting during a military deployment. Paid family leave benefits are available when a family member is deployed abroad on active military service, or who has been notified of an impending call or order of active service abroad and assistance is needed. Reasons for paid family leave for an active service deployment are the same as the military provisions of the Federal Family Medical Leave Act, or FMLA. They cover the employee's spouse, domestic partner, child, or parent. There are a number of instances where paid family leave will help, shown here on the screen. Now let's look at the program benefits and contributions for 2025. Eligible employees are able to take up to 12 weeks of paid family leave at 67% of their average weekly wage, capped at 67% of the New York State average weekly wage. An employee's average weekly wage is based on their last 8 weeks of pay prior to taking paid family leave. For 2025, the New York State average weekly wage is $1,757.19. That means the maximum weekly benefit for 2025 is $1,177.32. This is $26.16 more than the maximum weekly benefit from 2024. The total maximum benefit of $14,127.84 if the employee takes all 12 weeks is over $300 more than 2024. It is important to note that the employees can take this paid time off all at once or intermittently, but it must always be paid in full day increments. A wage benefit calculator is available at the link on your screen. Paid family leave is fully funded through employee contributions. The contribution rate is reviewed annually and is by the New York State Department of Financial Services. In 2025, the payroll contribution is 0.388% of the employee's gross wages each pay period. The maximum annual contribution is $354.53. Employees earning less than the current New York State average weekly wage of $1,757.19 will contribute less than the annual cap of $354.53. consistent with their actual wages. To estimate deductions, you and your employees can use the 2025 payroll deduction calculator on the Paid Family Leave website. So to summarize, the benefits and contributions for 2025, both the maximum benefit and the employee contribution are rising. The maximum weekly benefit is increasing from $1,151.16 to $1,177.32. The total maximum benefit an employee can receive is $14,127.84, an increase of more than $300 from 2024. Employees will pay 0.388% of their gross wages each pay period, capped at an annual maximum of $354.53. This is about $20 more than 2024. Employers can begin deducting at the new rate as of January 1st, 2025. Now that we've covered the types of leave, the benefits, and the costs, let's review who is eligible to take paid family leave. Most private employers with one or more employees are required to have paid family leave insurance for their employees. Public employers may opt into the program. Employees of public employers who are represented by a union may be covered if paid family leave is collectively bargained. For covered employees, eligibility for taking paid family leave depends on meeting specific requirements for the amount of time employees have worked for their employer. Full-time employees, including domestic workers, who regularly work 20 or more hours per week are eligible for paid family leave after 26 consecutive weeks of employment with the same employer. Part-time employees who work a regular schedule of less than 20 hours per week are eligible after working 175 days, which do not need to be consecutive. Citizenship or immigration status is not a factor in employee eligibility. Paid family leave coverage is not optional for eligible employees. Employees can waive coverage if they regularly work fewer than 20 hours per week and won't work 175 days in a year, or if they regularly work 20 or more hours per week, but won't be in employment with their employer 26 consecutive weeks. Seasonal workers are a good example of this, as they may work full-time, but for only 3 months out of the year. If it is waiving coverage, the employer must provide them with a waiver form, which is also available on the link on your screen. Employees who properly file a waiver will not make contributions and will not be eligible for paid family leave benefits. Employers should keep a copy of an employee's waiver on file. If an employee's schedule changes, such as they are no longer qualified for a waiver, their waiver will be automatically revoked within 8 weeks of the schedule change. An employee can also voluntarily revoke a waiver at any time. If an employee's waiver is revoked, their employer will begin taking paid family leave contributions and collect any retroactive amounts due. Keep in mind, however, that any amounts collected in excess of the paid family leave premium charged by your carrier must be promptly returned to employees. Now let's review how employees request paid family leave and the employer's role in this process. Before applying, the employee must notify the employer at least 30 days before their leave will start, if it's foreseeable. Otherwise, they must notify their employer as soon as possible. Next, the employee will obtain the request form package for the type of leave they need to take and complete the request for paid family leave form PFL1 following the instructions on the cover sheet. They will make a copy for their records and submit it to their employer. The employer must fill out the section of the form and return it to the employee within 3 business days. This information includes such items such as the employer's address, FEIN, employee's date of hire, last 8 weeks of wages. If the employer does not complete their portion of the form, the employee can still submit the form and cannot be denied solely based on the employer not filling in their portion. Employees will submit form PFL1, the other request form specific to the leave that they are taking, and supporting documentation directly to the employer's paid family leave insurance carrier. They can submit their request before or within 30 days after the start of their leave before they risk losing benefits. It is the employee's responsibility to submit the completed request forms, not the employer's. In most cases, the insurance carrier must pay or deny benefits within 18 days of receiving the completed request package, or the employee's first day of leave, whichever is later. Employees can get paid family leave request forms on from their employer's insurance carrier, or directly from the paidfamilyleave.ny.gov forms website or webpage. If for some reason an employee's paid family leave request is denied, or they have another claim-related dispute, such as amount of benefits or timeliness of an insurer's decision, they may request to have the decision reviewed by a neutral arbitrator. The insurer or employee, if self-insured, will notify the employee of the reason for denial and provide them with information about requesting arbitration. Arbitration for paid family leave is handled by NAM, the National Arbitration and Mediation. More information arbitration is available at the website on your screen, nyspfla.namadr.com. As mentioned earlier, an employer may not discriminate against an employee for requesting or taking paid family leave, and an employee is guaranteed job protection with the same or a comparable job upon return from paid family leave. If an employer does not return an employee to the same or comparable job, terminates the employee, reduces the employee's pay and or benefits, or disciplines an employee in a way as a result of the employee requesting or taking paid family leave, the employee can file a discrimination claim with the Workers' Compensation Board. An administrative law judge may order an employer to reinstate the employee, pay any lost wages, pay attorney fees, and pay up to $500 in penalties. The process and forms are available at paidfamilyleave.ny.gov, or employees can call the Paid Family Leave Helpline for assistance at 844-337-6303. Paid family leave was designed to be easy for workers and employers. I will now walk you through a checklist of employer responsibilities. Most private employers in New York State must have paid family leave insurance. Insurance coverage is in place. Ensure coverage is in place. Generally, if employers are required to carry disability insurance, they are also required to carry paid family leave. This insurance is generally added to an existing disability insurance policy. Employers who are self-insured for disability must purchase a separate paid family leave policy or apply to the New York State Workers' Compensation Board to self-insure. For a list of insurers offering paid family leave policies, visit the Paid Family Leave section of the Department of Financial Services website at dfs.ny.gov/PFL. Inform employees is your next step. Employee handbooks or other written guidance to employees must be updated to include information on paid family leave. To make this easy for employers, we have posted model language on the employer section of paidfamilyleave.ny.gov. Employers can customize it or just fill in a few blanks or print as is. Step 3 here, we have collect payroll contributions. Employers should be withholding at the 2025 contribution rate as of January 1st, 2025. Step 4, offer waivers to employees who qualify for one. Employers should identify any employees who qualify for a waiver. These are employees who regularly work fewer than 20 hours per week and won't work 175 days in a year, or who regularly work 20 or more hours per week, but won't be in employment for 26 consecutive weeks. If an employee meets the criteria for waiving coverage, the employer must provide them with a waiver form. As we shared earlier, if an employee waives coverage, they will not be making contributions and will not be eligible for paid family leave benefits. Employers should keep a copy of the employee's waiver on file. And our 5th one here is post an employee notice. Insurance carriers provide employers with a notice of compliance, Form PFL 120, also known as notice to employees, stating they have paid family leave insurance and providing employees key information about the benefit. Self-insured employers can get this notice by contacting the board at certificates@wcb.ny.gov. Employers must post and maintain this notice in plain view, similar to how the signage for workers' compensation and disability insurance is displayed. Employers who receive a paid family leave claim must complete the employer section, Part B of the Request for Paid Family Leave, Form PFL-1, and return it within 3 business days. The employer will be asked to provide the employee's last 8 weeks of gross wages and calculate the average weekly wage. Employers should be sure to discuss any specific leave tracking or other processes with their paid family leave insurer. We're frequently asked about similarities and differences between paid family leave and FMLA. There are several similarities between New York's paid family leave and the Federal Family and Medical Leave Act. Both provide leave for bonding with a child, caring for a family member with a serious health condition, and assisting when a loved one is deployed abroad on active military service. Employees are also guaranteed that they'll return to the same or a comparable position and their health continue on the same terms as if the employee had continued to work. If employees contribute to the cost of their health insurance, they must continue to pay their portion of the premium cost while on leave. But there are several key differences. PFL is paid, FMLA is not paid. Almost all private employers will carry PFL insurance. The FMLA does not include insurance and it has 50 employee threshold for eligibility. The length of time you must work is different. In PFL, if you regularly work 20 or more hours a week, you must be in employment for 26 consecutive weeks for that employer. And if you regularly work fewer than 20 hours per week, you must work 175 days for the same employer, which do not need to be consecutive. For FMLA, you must have worked for a full year and 1,250 hours in the last 52 weeks to qualify. The biggest distinction may be that under New York's paid family leave, you are taking leave to care for someone else, not for your own health condition. FMLA allows you to take leave for your own health condition. PFL is only taken in full day increments, and FMLA may be taken hourly. Also, under PFL, you do not need to use other paid time off first. There are several resources from New York State to help employers understand and communicate about New York State paid family leave to their employees. Complete details on paid family leave are available at paidfamilyleave.ny.gov, along with other resources including paid family leave request forms, fact sheets, weekly deduction, and benefit calculators, and more. There is also an updates for 2025 page on the website that outlines these changes for 2025 and offers a number of employer resources to help explain and communicate the benefit and deduction changes. These include FAQs, updated model language for employee materials, an updated template employers can use to provide notice of the 2025 payroll deduction, the employee statement of rights for paid family leave, and more. So visit paidfamilyleave.ny.gov/2025 to access these materials. You can contact the Paid Family Leave Helpline at 844-337-6303 for assistance. If you are not already subscribed for email updates on paid family leave, you can subscribe by clicking the Get Family Leave Updates at the bottom of the paidfamilyleave.ny.gov homepage. Finally, we also want to make sure you're aware of the board's Office of the Advocate for Business. The Office of the Advocate for Business is a liaison between New York's business community and the Workers' Compensation Board, giving employers one place to contact for answers to their workers' compensation questions, as well as any questions employers may have about paid family leave as it relates to your business. You can contact the Office of the Advocate for Business at advocatebusiness.ny.gov. New York State's paid family leave is administered by the Workers' Compensation Board. If you are not already following the board on social media, we encourage you to do so. We are on X, Facebook, Instagram, YouTube, and LinkedIn, so link up with us. You can also subscribe to get board updates on other benefit systems we oversee, workers' compensation and disability benefits, by hitting Get WCB Notifications on the bottom of wcb.ny.gov. We hope you found this presentation helpful, and thank you for the opportunity to discuss New York's landmark paid family leave with you. We will now review your questions. But as I mentioned earlier, please keep in mind that the board is unable to provide legal advice, which includes guidance about what you should do in specific situations. If you have a specific question or concerns about a request for paid family leave, you should contact your disability and paid family leave insurance carrier, as they are the entity that makes this decision to pay or deny benefits. So thank you all for being a part of this presentation and listening. I know that Courtney is going to be taking over shortly to answer all your questions. I did see in the chat coming through that people were asking about if these slides or the recording would be available, and it will be posted shortly on our Workers' Compensation Board YouTube page. And we will also send a link out in an email that you will receive a recording of this as well. So with that, I will hand it over to Courtney.
Great. Thanks, Sarah. So the first question that I see here is fiance included in the qualifying family member? So fiance isn't explicitly included as a family member in the PFL law, but like we talked about, domestic partner is included as a family member, and domestic partner is defined pretty broadly under the PFL law. So it's possible that a fiance is considered a domestic partner. So that's someone who's at least 18 years old and dependent upon the employee for support. And then there's like a nexus of factors is what the law uses. So common ownership of real or personal property, common householding, children in common, signs of intent to marry, shared budgeting, length of the personal relationship. These are all factors that the carrier would be looking at to determine whether or not a fiance would be a domestic partner under the law. And in many cases, they would be considered a domestic partner and therefore a family member. Okay, next question here is, if a daughter of an employee is giving birth, can that employee apply for caregiver leave since it's not a serious illness? So I just want to caution you about making kind of blanket statements or assumptions about what is or isn't a serious health condition. It is completely possible that recovering from childbirth is considered a serious health condition under the law. So if an employee is applying for their family members, so in this case a daughter, they're going to have a healthcare provider certify a serious health condition. And if they do that and they're eligible and they have all of the required documentation, they would be able to take paid family leave in that situation. It is not up to the employer, it is up to the carrier. And the healthcare provider certifying the serious health condition. So if the healthcare provider certifies a serious health condition, generally a carrier is not going to question that. They're not doctors. So I would just caution you about making assumptions about what would and wouldn't be covered. But if we're talking about the employee's child and they have a serious health condition that's certified by a qualified health care provider, they would be able to take leave in that situation. Okay, next question here is, do employers have to give the employee the PFL-1 or do employees go to the PFL website to get it? So this is kind of like a either or situation. The employer can provide a PFL-1, and in fact, many times the carrier has their own branded version of the form. So they may provide it to the employer to provide to the employees, but the employee can always go to the PFL website and apply using the appropriate form. The versions on the PFL website are the ones prescribed by the chair. The carrier always has to accept the ones on the website. Even if the carrier has their own branded versions, they still have to accept those. And then if they do have their own branded versions, they can't ask other questions. Usually what happens is they just kind of change the header to show you this is, MetLife or Shelter Point or whatever the carrier is. Like they're saying, this is our form that you can use to apply, but they have to accept the versions on the PFL website as well. Okay, next question here is how long do employers have to keep employee waivers? So you should keep an employee waiver on file the whole time that the employee has executed a waiver. So this is kind of essentially it's a best practice for you, because if there's ever a question about eligibility, about an employee taking leave, about deductions that you have or have not been taking, etc., you're going to want to have the employee waiver on file to show this person qualified for a waiver and they executed it, etc. So you would want to keep the employee waiver on file the entire time that the employee is in employment with you. Okay, next question here. Just as continued health insurance, isn't it only for 3 months by law? When we're talking about continued health insurance, we're talking about while the employee is on paid family leave. So an employee on paid family leave is entitled to keep their health insurance on the same terms as if they had continued to work. So this is essentially while they're on paid family leave, it's as if they were still working that whole time. If they contribute to the cost of their health insurance premiums, they have to continue paying their share of that cost. So it's just as if they had continued to work. I mean, there is a maximum of 12 weeks of PFL available to an employee in a 52-week period. So, that works out to 3 months. But when we're talking about continued health insurance, we're specifically talking about the employee being on paid family leave and then their health insurance continuing on the same terms as if they had continued to work during the period of paid family leave. Okay, next question here is asking if an employee took PFL starting August 2024 and then completed July 3rd, 2025, does the employee need to wait 26 weeks before they can take paid family leave again? So paid family leave is calculated, the availability of paid family leave is calculated based on a rolling calendar period. So in any 52-week period, the employee can only take a maximum of 12 weeks of paid family leave. So what that means is, like, for each day that the employee is requesting paid family leave, the carrier is going to look back 52 weeks and see how much leave is available to them. So it's a rolling calendar leave. So this is different sometimes from FMLA might use a calendar period, so a 12-month calendar period, and that's how you calculate the 12 weeks. This is not that. This is a rolling calendar period. And I see a follow-up question about FMLA using the 12-month forward-looking measurement period, and I cannot provide legal advice, and the board doesn't have jurisdiction over federal law, so I'm not going to be able to kind of speak on the availability of FMLA to an employee. Okay, next question here is what happens if you've had a part-time employee but no waiver form was ever provided? Can you give one now? So you have to give one. If the employee has been qualified for a waiver the entire time and you never offered them the chance to waive, you A, have to offer them the waiver, and B, you have to refund. So if they choose to execute a waiver, you have to refund every deduction that you've ever taken from them. Before you take deductions from someone who qualifies for a waiver, you are required to offer them the waiver. If you failed to do that and you took deductions from them, and then you say, oh, I was supposed to do this, and then you do it. If that employee chooses to execute a waiver, you have to refund every deduction that you ever took in error from them as well. Okay, next question here is, for employees who wish to take intermittent leave, can employers request a schedule that does not cause a hardship? So there's nothing in the PFL law or regulations preventing or prohibiting an employer from discussing an employee's leave schedule with them. But I would just caution you that employers are prohibited from discriminating or retaliating against an employee in any way because they take or request paid family leave. And if the employee thinks that you've done so, they can file a discrimination claim, which would be heard before a workers' compensation law judge. But there's nothing preventing you from discussing it. There's also generally employees who are eligible can choose whether or when to take paid family leave, and it is not up to the employer, it's up to the carrier to process and pay or deny those benefits. So there's nothing preventing you from discussing it with them, but you cannot discriminate or retaliate against them. And generally speaking, it is going to be up to them when they take paid family leave. Great. Next question here is, does the 67% of average weekly pay include overtime pay paid within the last 8 weeks? So average weekly wage for paid family leave is calculated using the last 8 weeks that the employee worked and received wages prior to the period of PFL. So that's just, it's always going to be the last 8 weeks that they worked and received wages, and then you're going to divide it by 8. And that's how you're going to come to the employee's average weekly wage. And then the benefit is going to be 67% of that. And wages includes kind of pretty much all of it would include overtime. It would include, your base pay. There are some other things that it would include. So it's any wages as defined under the regulation. And then you would divide it by 8. And that's how you come to the average weekly wage. And then the benefit is 67% of that, or 67% of the statewide average weekly wage, depending on how much the employee makes. So I see a question here about including disability into paid family leave. So the law is the disability and paid family leave law. To change the disability benefit amount would require an amendment to the law. So if you believe that the disability benefit should be increased, I highly encourage you to talk to your representatives, your state representatives, because we have no control to change it here. It would have to come through an amendment to the law through an act of the legislature. Okay, next question here. Is it required to provide the payroll contributions to employees? So I think that you're probably asking, is it required to take payroll contributions from employees? So PFL is, the way the law is written, it's fully funded by employee contributions, and covered employers are entitled to take PFL contributions from their covered employees to cover the cost of having those employees on their PFL policy. You are not required to take deductions from your employees if you don't want to. If you wanted to just cover the cost and pay for the PFL policy without taking deductions, you are free to do that, but you don't have to. So the laws are in so that the employer isn't required to fund any part of the PFL policy. Okay, I see a question here saying, for FMLA, can employers require employees to use their other leaves first? And what if employees want to use paid family leave instead to not use their sick time? So paid family leave and available FMLA, the employer can require those to be taken at the same time. So say the employee is eligible for FMLA and they're eligible for paid family leave and they're going to take like bonding leave or something. The employer can require them to take bonding leave for both FMLA if they have it available to them and they're eligible, and paid family leave at the same time. If we're talking about just FMLA, that's outside the jurisdiction of the law. If we're talking about just paid family leave, the employer cannot force the use of accruals or paid time off. The United States Department of Labor issued an opinion letter in January answering this question about when it's FMLA and paid family leave together. And that opinion letter said if it's a state paid family leave and you're not required to use accruals during that and it's FMLA, the employer cannot force the use of accruals during that period either. So if we're talking about paid family leave time, the employer cannot force the use of accruals. Okay, next question here is, does someone applying for paid family leave to take care of a sick relative have to provide proof of their relationship to the relative? So on the PFL application form, the employee is certifying that everything that they're saying is true. There are questions about the relationship to the what family member is this, the healthcare provider certification. If the carrier needs more information, they can follow up from the employee. But the application requires the employee to actually attest that everything that they're saying is true, and it does ask about the relationship to the employee to make sure that that family member is in fact a family member. Great. Next question here is, if an employee takes disability and then PFL, would job protection be for the 12 weeks still? So paid family leave, if the employee is on paid family leave, that is job protected leave. The employee is entitled to return to the same or comparable job upon return from that period of paid family leave. That period is job protected. Disability does not have a similar protection in the law. So if we're talking about disability, there's no explicit disability protection. There are other protections. So if it's like leave for pregnancy or something like that, like there's Division of Human Rights, there's a lot of other laws that would protect an employee from kind of discrimination, retaliation, but the specific discrimination, retaliation, job protection, return to the same or comparable job, that applies to paid family leave under this law. Okay, next question here is, does PFL pay if the leave falls during a school recess? So a day of paid family leave is defined in the regulations as any full day that the employee was prevented from performing work because the employee took paid family leave. So if an employee is, for example, a teacher and they don't work during the summer, they can't take paid family leave during the summer either, because then they're not prevented from performing work because they took paid family leave. They're prevented from performing work because they don't work during that time. So it's a paid family leave, meaning it's leave from your job that you need to care, to take care of one of these family situations. So if it's a day that you don't normally work or a time period that you don't normally work, you're not going to be able to take paid family leave during that time. Okay, next question here is, why would someone use FMLA if they can use PFL? So when would anybody use FMLA? So FMLA and paid family leave have A, different eligibility requirements, B, some different qualifying events. So paid family leave, like we talked about earlier, is to care for someone else. So it does cover many of the same events as FMLA, but FMLA can be used to care for yourself. Another situation might be, you used you may be eligible for FMLA. You've taken your FMLA for yourself, then you could take paid family leave if you had a different qualifying event. So there are different situations, but probably the most common one when we're talking about you using unpaid FMLA instead and you're eligible for PFL is probably if you need to use it to care for yourself. You may be eligible for disability during that time, but you would not be eligible for paid family leave to care for yourself. So that's probably the biggest example of when you would do that. Okay, next question here is, can someone opt out of paying for PFL taxes? So PFL contributions are not optional for eligible employees. The covered employer is entitled to take them from their covered employees to cover the cost of having those employees on their PFL insurance policy. The employer can take deductions at the rate set by DFS, and they can only use those deductions to pay for their PFL insurance policy premium. If the employee is eligible and does not qualify for a waiver, they cannot opt out of that. The employer is entitled to take benefits or take contributions from them. Okay, I see a very specific question about companies under an umbrella and transferring companies. Can we take the hire date from the previous company to qualify for PFL? Generally speaking, paid family leave eligibility is calculated separately per covered employer. Whether or not an umbrella company and then these other 4 companies are considered one employer is extremely fact specific, and I can't provide legal advice, so I'm not going to be able to tell you yes or no. If the employee believes that they're eligible and the employer thinks that as well, like the employee is free to apply to the disability and PFL insurance carrier. And then if they receive a decision they disagree with, they can file for arbitration. But I cannot provide legal advice, so I'm not going to be able to tell you, yes, this counts as eligibility, or no, it doesn't. Okay, next question here is, what if we have an employer policy that covers paid family leave? Are we able to withhold for PFL from the employee's pay? So I want to make it very clear that if you're a covered employer, meaning you have one or more employees in employment in New York State on each of at least 30 days, you are required to have statutory disability and paid family leave coverage for your covered employees. So regardless of whether or not you as an employer provide a benefit on top of paid family leave, you have to have coverage for paid family leave. So just saying, oh, we offer maternity and paternity leave, or oh, we offer, leave for these different reasons. If you are a covered employer, that is likely not sufficient. You actually have to have disability and PFL insurance coverage. And then, yes, you would be entitled to withhold for PFL as a covered employer to cover the cost of having those employees on that policy. And then the deductions that you take would fully cover the PFL insurance policy premium. Okay, next question here is, can an employee apply for paid family leave if the person they need to care for is out of state? And the answer is yes. There is no requirement that the family member be located in New York State or even inside the country. They could be located outside the country. The kind of caveat to this is that the employee who is taking leave to care for the family member, they do have to be in close and continuing proximity to the family member during the majority of the leave period. So that means they actually have to be present at the same location for the majority of the leave period. So you couldn't say, my father had a stroke and I need to go care for him in another country and then stay home for 12 weeks. But if you were going and actually traveling and caring for that person, they do not have to be located in New York State. They could be out of state or out of the country. Okay, next question here is, if the carrier is saying unspecified for PFL intermittent leave, can the employer say how much time the employee can take then, or is it still the employee's right? So no, the employer has no control over how much leave the employee takes. It is up to the carrier, within the confines of the PFL law or regulations, to process and pay or deny the benefits. What the employer can do if the employee is taking intermittent leave is you can require notice before each day of intermittent leave. So that's at least 30 days if the leave is foreseeable, or as much notice as possible if the leave is not foreseeable. But you can require notice before each day of intermittent leave so that you know when the employee is on leave. But as far as denying leave, the employer has no ability to deny leave. Okay, next question here is, does New York State paid family leave and FMLA have to be run concurrent, or could it be stacked? So generally speaking, available FMLA and PFL for the same qualifying event is going to be run concurrently, so at the same time. The employer could allow the employee to take the leave separately if they chose, but the default setting is going to be that they are taken concurrently. So the employer can require it, they just have to kind of notify the employee, but the default under the law is that unless the employer explicitly says you can take them separately, they're going to be run concurrently and at the same time if it's available FMLA and PFL for the same qualifying event. Okay, next question here is, when onboarding, do you have to offer a PFL waiver if they don't want to pay for it? So only 2 categories of employees qualify for a waiver. And for those 2 categories of employees, you have to offer them the waiver prior to taking any deductions to them. But it's only these 2 categories. So the first is an employee who regularly works 20 or more hours per week, but they won't be in employment for 26 consecutive weeks. So this is usually like a seasonal worker or something like that. The second category is an employee who regularly works less than 20 hours per week, but they won't work 175 days in a year. Those are the only 2 categories of employees who qualify for a PFL waiver. Okay, next question here is it required to provide the employee payroll notice to employees for employee payroll contributions? So if we're talking about the one that's on the PFL website, it is strongly recommended, but not explicitly required in the PFL law and regulations. If we're talking about you're opting in to cover some employees, and then you're going to take deductions. Like that has another set. I don't think that's what we're talking about, but that has kind of another set of requirements where you actually have to get the assent of more than 1/2 of the employees before you can take contributions. But as far as if we're talking about the employee payroll notice that's available on the PFL website, it is not explicitly required to tell them, here's the new rate. It's strongly recommended though. It can save a lot of headaches, and we do it for you. It's available on the website. So it is strongly recommended, but it's not an explicit requirement in the law. Okay, next question here is, so if an employee signs the opt-out of PFL benefits, but later on decides they need PFL and wants to revoke the waiver, can they do so immediately? And does the employer then have the right to take contributions retroactive from their higher rate? So the waiver is optional and the employee can decide to revoke the waiver at any time. If the employer revokes the waiver, then yes, the employer can A, start taking deductions going forward, and B, take deductions retroactive from the time of from the waiver period. A kind of thing that you want to keep in mind on that is like if you've had this employee for 5 years or something, and then they decide to revoke the waiver, and you're going to take deductions going forward and you're going to take retroactive deductions. Just something to keep in mind is that you can only use the PFL deductions to pay for your PFL insurance policy premium. So even though we're talking about retroactive from their hire date, in reality, you're actually not going to need to take that many deductions because otherwise you'll have a surplus. So because you're only paying for a year policy, if that makes sense. So yes, you can take retroactive deductions. It's just keep in mind that you can't take kind of more than you need to pay for the PFL insurance policy premium. Okay, I see a follow-up question just asking about a phone number where someone can assist me because you may not be asking your question correctly. Yeah, so Sarah's just going to go back. So right up at the top there, you can see the PFL hotline. So that's a number that you can call to kind of get more assistance through the helpline. And then if the helpline doesn't have the answer, then it will come to the Office of General Counsel and it will be me or another attorney. If it's a speak, it will be me. But yes, that's the number that you can call. Okay, I see another question saying, also, what happens if you cannot provide all 8 weeks of wages of a company takes over a new company? I am not sure I understand your question, so if you want to kind of rephrase and re-put it in the chat, I can try to answer. Otherwise, the PFL helpline is up there as well, but I am not sure I understand your question, so please feel free to put in the chat additional context. Okay, I don't see any other questions right now, but we will hang out a couple minutes. If you have any other questions, please feel free to put them in the chat.
I did see that we had a question come in regarding where they can find the webinar, where the recording of the webinar will be. I had mentioned earlier, we will email a link out that will send you to our board's YouTube page where we host and we keep this webinar and a bunch of our other webinars that we do on other topics. If you haven't been to the workers' compensation, New York State Workers' Compensation Board YouTube page, I strongly recommend you go there. There's tons of different resources and webinars that you can view at your leisure.
Okay, thank you. So we got additional context on the other question. So it's if we cannot provide all 8 weeks of wages because the company used to be under another company but is now under a new company, so we only have 4 of those weeks, for example. So this is kind of a complicated question. The answer may be that the employee is not eligible for paid family leave yet. There are some limited circumstances where an employee may be eligible for leave after an employer changes hands. I am going to put in the chat, just so you have it, like the section of the regulations, but this is a very fact-specific question. Generally, when we're talking about gaining eligibility for paid family leave, eligibility for paid family leave is calculated separately per covered employer. So if an employee changes employers, they're going to have to regain eligibility for paid family leave. Okay, so I just put in the chat just to everyone, so you all have it. But this is kind of the section of the regulations we're talking about. There are some limited circumstances where you may continue to be eligible, but generally speaking, they are going to have to regain eligibility. If the employee thinks they're eligible, they are free to apply to your disability and paid family leave insurance carrier, and then they could request arbitration to have it resolved by a neutral arbitrator if they receive a decision they disagree with. But generally speaking, they would need to regain eligibility if it was a different employer and now it's a new employer. So it's very fact specific, and unfortunately I can't provide legal advice. Okay, next question here is, how do you go about refunding an employee if they were eligible for a waiver and had already paid 3 months of coverage? So if you took deductions in error from your employees, like an employee who was qualified for a waiver and you just mistakenly didn't offer them a waiver, then you realized your mistake, offer them a waiver, and then they execute a waiver. So now you have to refund the deductions. The board does not prescribe how you do that. So you just have to refund the amount of deductions that you took in error. We do not prescribe how you do that, though. Okay, we'll see if anybody has any other questions in the next minute or two here.
Okay, well, I don't see any other questions coming in the chat. So Courtney, thank you very much. And thank you to everyone for joining us today. If you see that another question came in, I'm going to go ahead and back up the slides to the helpline, and we'll see if you can go ahead and call them there and they can answer the question that came in. Sorry for catching you off guard there. You can also sign up to receive paid family leave news, including information on future webinars, straight into your inbox. To sign up, visit the Paid Family Leave website, scroll down to the bottom of the homepage and select Get Paid Family Leave Updates. We also distribute information via our social media channels, so please follow the board on Facebook, X, Instagram, and YouTube. Once again, we thank you all for joining us today and enjoy the rest of your afternoon.